Well, so you have, Michael, a super interesting case study.
Yes, I do.
And as usual, we're going to be really careful about
right.
not divulging any information that will identify parties, but we kind of alluded to this one in a recent podcast, but it's just too juicy to leave alone.
It is.
So can you set it up?
It just shows you what a small world it is. So I had a sex assault trial. When was it? Spring, I think. It finally
Spring,
happened.
yeah.
He says, she says. I'll tell you a little bit about the facts because they were also interesting. So, they meet at a university party, first week of September. Total strangers. He likes her, she likes him. They hook up, end up having sex in his car down the street. She even hands him the condom. He thinks, oh, wow, this is cool. They exchange Instagram information at the end of all that.
What's that called? Exchanging your handle? Or something? Yeah.
That sounds kind of rude, but they exchange
I
that
think
too.
somebody can correct me, but I think
Yeah, it's probably...
you don't give out phone numbers. You
No,
exchange your Insta handle or something.
Yeah, who uses phone numbers anymore?
Anyways.
Anyway, he goes on his merry way thinking, okay, that was fun. That was good. Continuing, first week, whatever, activities at the university. Then months pass. Then he gets charged with sexual assault from that incident. Scratching his head, going, unbelievable. Like the nicest kid, young guy, no criminal record, no problems in life at all, except when this came up. So, of course, we did the standard trial preparation, the chronology, the draft cross-examinations, the draft examination, the practice sessions. We practiced the hell out of this. Had our trial. Thank God, towards the end, the Crown just gonna put her hands up and looked at me and said, after my cross-examination, she goes, yeah. The complainant was sitting there with her stuffy support frog. I was trying not to offer one of my kids' old stuffed animals to her, but whatever. And the Crown basically, at the end, just invited the judge to toss the case. And the judge agreed. The complainant was horrible. She was not bad in chief with the Crown, but as soon as I stood up and started chipping away at stuff, she just fell apart. So fine. Another success story for Neuberger and Partners LLP. Drive home from London. All is great. And then we get a new intake not long after that. And same sort of pattern, boyfriend, girlfriend. The relationship was a bit longer. And so it's set for trial in the fall. And thank God for our Amy. Amy's the best. She's one of our admin, and she loves going through this stuff. So she was, organizing disclosure for me. And she said...
Don't call her admin. Call her office manager.
I'll call her she who must be obeyed.
Case assistant or something.
She's she who must be obeyed.
Yeah.
That's who she is.
Very particular about that.
She's very good. In any event, she was going through the disclosure, and similar names started popping up. The complainant's father from this case I just won. And it was the same complainant, of course. So, Amy, Burry, come here. I go, what? I'm busy. No, Burry, come here. You need to see this. So, yes, Amy? She goes, look at this. And I'm like going, are you oops. Sorry, you'll beep that.
No, I swear all the time.
Yeah, that's right. You do.
You never swear.
I'm not to swear, so I just did, folks. Thank you.
About time.
Yeah, it's the virgin swear or non-swear. In any event, it's like, oh my God.
Same complainant.
I cannot believe this. So we start parsing the disclosure, going through our process. Very similar type of scenarios, but a longer relationship. She apparently had dumped this guy after she had chewed through the first guy that I won the trial for. So we're preparing, getting ready our motions, pre-trial motions. And of course, as we do with our clients, give us the digital dump. Give us everything you got. We got a lot of text messages, a lot of photos, but something didn't sit well with me. I'm scratching. This can't be everything. Client was very shy.
Yeah, like extremely shy. And
very shy.
Understand.
Very shy. So I had him in for a meeting, and I said, I think you're holding out on me, aren't you? He goes, yeah. I go, what do you mean by, yeah, this is your trial. We need everything now. Well, there's sex tapes. I'm going, giddy up. Can we sell them, more importantly? No,
I've got popcorn ready.
Yeah, I've got popcorn ready. Can you give us these sex tapes? And he was mortified, obviously. And it was her, the complainant.
And it's not a situation where it was made to send out or share or do anything. He just literally had it.
Both of them, consensual. She's moving his hand. He's doing stuff too. And it's not like this was some surreptitious camera that he had hidden somewhere. This was like they were putting on a show.
Yeah, so let's stop for a moment because we did talk about this. So the video is extremely compelling because it shows the engagement of the complainant in the making and orchestrating of the video.
Right.
And it is the sex in the video for which she's complaining that she was sexually assaulted.
Right.
Can you just set up, without giving anything away, what her actual allegation was juxtaposed against the video?
Well, her totally non-consensual rape, like
Forced down.
like everything, the whole shebang, the whole menu. She was accusing him of, right? So it was.
So she was accusing of basically a forced, full-on rape.
Right.
Forcibly confined, held against her will, didn't partake whatsoever. There's nothing consensual about any of their activity.
Against her will.
Yeah, false allegations are a myth, right?
They're a myth. They don't happen, folks. So I said, give me the sex tape. I promise we won't sell it. So he finally delivers the sex tape. And I'm going, whoa, that's impressive. That's a good piece of porn. It was like she was like a porn star. The blowjob, like everything. The looking at the camera, are you getting this? I'm really good. I'm like going, why didn't you give me this before? Like we could have, like
He was very mortified.
And then I said, okay, well, give me the metadata too. And the metadata, totally consistent where they had rented an Airbnb, the times, everything, like no doubt. It's the same day, same time period, same location.
And you've got the metadata.
Yeah. So we had all that.
So this is literally the subject matter of the charge.
Right. Totally. Complete subject matter of the charge. So I talked to you, you talked to me, we talked to Amy. Good job, Amy. And we're going, wow. How often does that happen?
Not often. Not often because, most people don't record it.
Right.
And there's good reason you don't also because there's that case law now that if you surreptitiously record it and it's found out by the complainant, she can complain about that and that can actually constitute a sex assault in and of itself.
The Ottawa case.
That said, there's something to be said for having a recording because it can exonerate you, but get you convicted of another type of sex. It's just ridiculous.
It's ridiculous.
So it doesn't happen. This is not often.
No, this is exceptional. This is the stars have aligned in the universe for both clients, really.
Like I long time ago, I took over a case from another lawyer, and it was at the prelim stage. And these were the good old days when we had preliminary inquiries on sex assaults. And I brought a 276, and I got my client to give me everything, which included multiple videos, of which were all the subject matter of the offense. And it was a long application. I think it was one of my longest, and this is way back, because you have to do it still under Section 276 if it's involving sexual content. And great judge. And we succeeded, and then cross-examination went on. Like I went on for about 2 days, and then the Crown invited a withdrawal, sought leave to withdraw. Nice. It was one of those rare occasions, but it was exactly the same type of idea. The videos and the content of the video, when you leave aside what they were doing, the actions of the complainant in the video, just like this one, completely. I wouldn't even say undermined. They just show that the complainant absolutely, unequivocally, bald-faced lied.
Right. Now, I don't know if she's, I've reached out to the Crown, no response yet. But as we talked about this case, we're going to look, this is what we have, cards down on the table. You still want to go ahead with this?
This will be withdrawn.
You think? I hope so. It's out of town. It's in a conservative part of the province, but... Well, come on, let's think of the scenarios with a complainant. Like, she's weaselly. She's very weaselly. Well, I consented for this part of the tape, but,
Yeah, it's not going to fly.
No, I know.
Because, and let's speak about this more in the hypothetical now.
Yeah.
is when you have a complainant who testifies about a series of events that are in essence a full-on sexual assault,
Right.
a full-on rape. And we're using rape now more than before because it's finding its way back into what complainants
Right.
are saying.
Right.
Because it's different than,
Right. A grab, a shove.
a grab, a shove,
whatever,
a touch, or something else happened during consensual activity. But, it's when you describe something of that vicious nature,
Right.
where it is, completely forced with no hint of anything that's consensual, the allegations themselves are just, black and white.
Right. Right.
And so both can't be true. And in this case, like others, we would automatically want to disclose this on a USB,
Right.
protect everybody's privacy interests, but have the Crown, view it with the idea of doing the right thing and withdrawing. But in this case, we're actually going to be suggesting that she gets charged.
Yeah. This is one of those times.
There's
One of
just
these
no way
rare-
around it.
No, there isn't. There isn't. And then she claims there's two sets of charges, and then another set of charges where he apparently sexually assaults her, not a rape, but whatever, grab, whatever, in the car that they're traveling on the way there. The pictures he sends me, she's smiling at him eating a sandwich he just bought her.
And you have all of the metadata for the pictures.
Yeah.
Like
It's terrifying.
yeah. I mean,
It's just terrifying.
yeah. It's bad. And, one of the things I also wanted to talk about during this episode, because it's a little bit of a case study, but I wanted to talk just briefly about peace bonds in relation to stuff, because there's a sex assault case that's being withdrawn
Right.
after we had succeeded on our 276, 278 application, again involving a nice young person who goes to university. Two people hook up at a party,
Right.
and in any event, after a fully litigated 276, 278 application, we're at the stage now where it's going to get withdrawn. And there was a simple condition asking for just a peace bond so that the two do not interact or come into contact. And I think it's important just to reiterate. I'm going to go back to the other one, but I wanted to segue for a moment. Even though when you have a case where it's pretty obvious what the outcome will be, if you're given an opportunity to have a withdrawal where you don't have a trial and all that goes on record and the charge is definitely withdrawn, because we can never give guarantees.
No.
A peace bond is a court order to keep the peace, be of good behavior, have no contact with the complainant, usually don't possess any weapons, and that's it. It's in place for a year. It's a court order similar to what you'd have on a release on a bail, and there's no admission of civil or criminal liability, but it allows the Crown to withdraw and then to say to a complainant, well, at least there's an order that you can't have contact.
Aren't you finding a lot of clients pushing back on that, saying, why should I enter a peace bond?
Yeah,
I'm
do.
innocent.
And we understand that sentiment,
Right.
but, and that's why we're saying this now. Because the peace bond really doesn't make a difference down the road. So you enter it without any admission of liability whatsoever, civil or criminal. So all it is a promise to the court to do X, Y, and Z. Even if somebody is withdrawn against without a peace bond, or if there's an acquittal at trial on the computer system, we've spoken about this before,
Yeah,
where I
CPIC.
said there's always a record. It's going to say the person's name, date of birth, the charge, disposition, withdrawn.
Right.
It sits there.
Forever and
If it
ever.
says peace bond, says withdrawn peace bond, it really doesn't make a damn difference. And in certain jurisdictions, you cannot have that expunged. Toronto police don't delete, won't get rid of it. It's going to remain there. And that's a problem for people going forward, because it has a significant impact if you have a vulnerable sector search
I was
or
going
other
to say
things.
the vulnerable sector stuff.
And sometimes if they deny it and it's a few years later, there's a way to appeal and to try and get it expunged at that time. But it's a whole process. But it makes no difference if somebody enters into a peace bond. And the benefit of it is Crown attorneys sometimes need that in
They
order
need to
to
sell the package.
They need to in order to get a withdrawal.
Right.
And it's very important to say, winning the best trial is the one where you get it withdrawn.
Right.
Where you can say guaranteed, charge is going to be withdrawn, you're innocent, you can go on with life. A withdrawal means innocence.
That's right.
In fact, you sign a peace bond doesn't mean you're not innocent. And there's always risks in going to trial. Leaving aside, the emotional and the psychological impact it has, because it's not easy.
Nope.
You just don't know.
No, you don't.
Because sometimes testimony for one or the other can be problematic. Can be problematic for an accused. You just never know how it's going to unfold.
There are, though, some risks with peace bonds, but minimal compared to risking a trial, obviously, right?
If you put it into the context of domestic, when you're in the middle of a high conflict divorce, where you are fighting over child custody and stuff like that, family courts will sometimes look negatively upon a peace bond. But one of the ways I found you get around that is you order the transcript of when you're doing the peace bond. And you specifically state things like, there's no admission of a civil or criminal liability. The Crown is withdrawing because there's no reasonable prospect of conviction. My client's entering into the peace bond in order to bring the conflict down so that these parties don't have to go to trial, which is in everybody's best interest. And when you get the transcript and then you stick that in an affidavit and put it before a family court judge, it does have an impact, because they can be brought to the idea that they're doing it to stop the process so that more doesn't happen.
Right. What's the difference between a Section 810 and a common law peace bond, people may want to know?
Well, Section 810 is Section 810
It's
under
codified.
the criminal code.
It's in the criminal
It's under
code.
the criminal code, and it automatically is put on the system. So it'll say Section 810 peace bond. Common law is pursuant to our common law.
Right.
And it is same thing, same force and effect. But sometimes it doesn't make itself onto the to CPIC.
A lot of people know that. Sometimes I try to push for common law. I say,
90% of the time we try.
810, it's all that paperwork. There's a form. Let's just do common law. And, and if you got the right Crown, they don't care which it is.
No, they're usually very, very good about it. But in the context of when you're faced with a sex assault case, and even if you find it's an overwhelming situation where you think you're just going to really win, sometimes it's very hard, in our opinion, and we've had great success over the years, and we really fight hard for the clients. When you get a withdrawal, it's good. And it's something, we would be negligent not to say to a client, this is something you should really take.
It's a lottery. It's a win. You won the lottery. You're getting withdrawn charges. That's it. Walk away.
But to circle back to what we were starting about, again, this is another example of circumstances where the factual basis of the allegations is really at play and not accurate.
Right.
And so, 2-3 examples now in a short span of time of where there's palpable evidence, particularly in this case, showing that's just not true.
She's a serial psycho accuser, right? That's what she is. She has relationships. It looks like it's short-term relationships. They fall apart. She doesn't like that they've fallen apart. Boom.
It's sad. Very sad.
It is very sad. Are we gonna have like a pause there after the word sad, or just?
Well, it's just the reason we brought this up, because when we spoke about in the other podcast, this application and some of the facts related to that one, where there's this litany of messages showing a completely different circumstance. When you take, again, another example in such a short period of time within this office, where I know I'm sort of reiterating this a little too much, but where you just can't compare the facts. It's like saying that that's not a bookshelf, but you have evidence showing it's a bookshelf. There's just no other way to try and deal with this. It is completely, starkly, a fabrication.
Yeah.
And yet, we still have concerns about how a Crown might want to view it, might want to try and play with the scenario.
Well, like I said, that part was consensual, but the part that wasn't videoed, that's where he really raped her. That's always I'm always fearful of that scenario. I know what you're saying, that, well, come on. It doesn't make sense.
In this case, it doesn't.
Not in this
we're
case.
duty bound, and this is something you should reiterate. We can't just surprise a complainant with this video, even though it's the subject matter of the charge, because the case law tells us if you have a record, even though it may be the subject matter of the charge, you're going to have to disclose it and do a 276, 278 application. We have no choice.
No, we don't.
And this is something worth thinking about. And this is where sometimes, we've said, I guess, in a number of our podcasts, that since the legislation coming in, we found that it really hasn't been a detriment to us at all, and judges have been very good with it. Crown attorneys have been generally very good. Nobody's been opportunistic. And at the times when complainants try and take advantage of knowing a defense ahead of time, because you have to disclose everything, it really hasn't worked out well.
No, it tends to backfire.
But this is one of those cases where we know we have to deal with 276 because it's the video. That said, if it's the subject matter of the offense, generally that should be an exclusion, no matter what. And there were the good old days when you could try and argue that, but I also erred on the side of caution to make sure that that we usually did a 276 application on it. But on occasion.
So explain what the exclusion things. I don't think people.
Well, I'm talking a lot. You go ahead.
Well, no,
this
you
was
tell
your
me.
Case there.
I was, but you're talking about this exclusion thing you used to argue. What did you argue?
Well, if I can establish that this
Right.
is literally the subject matter of the offense,
Right.
in the older days,
Yeah.
December 2018, there's no reason for me to do a 276,
Right.
Because it's prior. At that time, it was prior sexual activity.
That's right.
Right. Now it's other sexual activity, but under, I think it's JJ, it's pretty murky that if you have a record, even if it's subject matter of the charge, it may still have to go through 276, 278 scrutiny.
I'll be livid if they put me through that with this client.
Well, I still think
In
that's
this
the way it is.
case.
But let's think about this for a moment. It should be clear in law that if we have the metadata and all the surrounding circumstances of the video, so that we could at trial say, here's all the metadata, we're going to put this into evidence.
Here's the Airbnb.
Here's the Airbnb. Here's everything that will establish that this is absolutely the subject matter of the offense.
Right.
It should be something we don't have to disclose. Because you can imagine at trial, the complainant testifies in chief, you start cross-examination where you just do something that the judge knows something's coming, right? You just hammer home, you just lock and pin down the complainant into the allegation where there can be no ambiguity
Time, date,
about what she's saying, or about
What? Yeah, the substance.
the substance of the allegation, and then comes the video.
Yeah.
And then it's over,
Yeah.
right? Because at that point, there's just no way getting back from it. We can't do that now.
I know, it's tragic.
This is the one circumstance which has caused me pause now lately because it's happened in this case, and there's another one I'm forgetting that we actually had audio recording of.
Okay.
And I cannot imagine being able to just pull it out and play it without an application and a judge not going crazy.
Yeah.
I just can't.
Yeah. And looking at the Crown saying, can we talk about this in chambers?
Yeah, I can't imagine. The one thing you don't want to happen is when you're at that moment in cross-examination, you don't want to be stopped, and then you don't want to be, if you're in front of a jury, it's bad.
Oh, yeah.
But you don't want to be stopped. You don't want your momentum coming to an end. You don't want to be lambasted because you haven't done something. And there is no way. There's another case, which wasn't ours, but it was well known, where the defense held back an audio recording of a discussion between the complainant and the accused about the subject matter of the charge.
Right.
And that did not go through a 276, 278 application. And the minute it was raised, and the judge understood what this was about, because there was a recording and a transcript put in, the judge lost it on the lawyer.
Yeah.
Shut it down, said you should have done this, you should have done that, stopped everything. It was in front of a jury. Ooh. And then they eventually allowed it in because it was clearly about the subject matter of the charge, but it was with a scathing rebuke of the defense for not having complied with the legislation. And that's something you don't want happening.
No.
And, I stand to be corrected because it's been a little while since I've gone through that part of JJ, but I think it's pretty clear because we put it into our newsletter that regardless if it's the subject matter of the charge, it's going to have to get vetted if it's a record.
Yeah, this is clearly a record. It's a video recording.
That's the one. So when we were talking about this ahead of time for this
Yeah.
for this episode, where it was just this case study about it, and it's again another stark example of what really is a false allegation.
Yeah. This one makes the top 10 list.
So, but in the last month, we can count on 3 to 4. Okay, that we have evidence to establish based on messages and other stuff. But this should be the one area where you have a consensual recording, where you can tell it's obviously consensual. Mm-hmm. I know I'm being repetitive. Where you have the metadata. This
is important.
Where you have the metadata. You have all the surrounding evidence to establish that this is in fact the subject matter charge. We should have the ability to determine a strategy that we think is best for our client, which could include not disclosing.
Right.
But we're going to disclose.
Yeah.
And we think there's no other way around it. It has to go into an application anyways.
No, we have no choice.
But this would be that one thing where I would have liked to have seen from the Supreme Court of Canada say, if there's a record in the possession of the accused, we just say accused because that's the language they're using in the in the case law, but in the possession of our client, it's clearly about the subject matter of the charge. There should be no reason for that to be disclosed.
Yeah, make an exception.
As it should be.
Because it just loses all of its steam in many ways. Once we go through the hoops, the motions.
But again, you know, in most of the cases where we've disclosed ahead of time, where we've had highly compelling evidence to show that this is false, Crown attorneys have wanted to do the right thing and withdraw.
Yeah.
They really have. But it's just, I think it's a confluence now of, in the last year, there's been just a number of cases that we've had where it's probably just over a year and a half where there's just been so many where it's been just so obvious that either 90 to 100% of it or 70% of the allegation is completely fabricated. And we've got sources of information that supports messaging, videos,
audio, everything.
All sorts of stuff. It begs the question, why do we need to have to disclose absolutely everything under this legislation? Why did this happen? And it comes back to the court saying twice now, you know, underreporting, under convictions, we have to do more. And then in a recent Supreme Court of Canada case, which I thought was actually quite favorable for the defense, the Kruk decision. Yeah. But the judge did say, you know, fabricated allegations of sexual assault are rare, and they're not
rare. How many this month?
I think it's why we've come back to this particular case study.
Because this one just perfectly demonstrates.
I can't think the one that we spoke about before that had all those messages, but this is real time.
It's like, here's the videos, that sex tape.
You can't
like,
you can't get around
that. Oh, we said that at the same time. That was kind of cool.
I know, it's just amazing. And you think about how little goes into an investigation, and how, thank God, you were digging deeper and deeper because you were looking at all the other stuff that the guy had provided, and you're like, there's something more here, because
spider senses
we won't talk about it, but I think I remember you saying that just the way they were communicating, you were thinking that there was more to it, and it's true. Some clients are very traumatized, embarrassed. They're not, they're private about this. It's very hard to come to strangers and talk about this.
Talk is talk, but the videos, like, I felt sorry for the guy.
Talk about, it was very, very hard. And thank God we've got it now.
Yeah, I just hope the Crown does the right thing. It doesn't make me jump.
We'll see.
Through those hoops. Yeah, we'll see.
But it was just something we had to reiterate, and I think it's a legitimate question going forward to revisit the issue about if you can really establish that one particular piece of evidence is about the subject matter of the charge, and it's so compelling because you have the evidence to support that. We should drill in to see if we can.
And in a perfect world, I'd be able to ask for disclosure of any occurrence reports involving her as a complainant. Because
you can't.
I know you can't, but
explain that for a second.
Well, she's done it once. She's done it twice. You think that's all? I doubt it.
And why can't we get that? Just explain so everybody knows.
Because we're not allowed to make that request, because it's if it's pending, it's charges that are not completed, right? So they're in another jurisdiction. The Crown will say, no, can't get those. privacy issues. There's just any number of issues that
Sometimes they'll still claim it's a third-party record.
third-party
although
record.
Case law says it's not.
It's not, but they're trying that in many cases.
So we're talking about, when a charge is laid, there's disclosure, but there's, a court information, and then there's an occurrence report. And the occurrence report is basically a summary drafted up by one of the officers about what
document
happened.
generated by the police. A summary.
So typically you will ask in a disclosure request, are there any other prior occurrences involving either the accused or the complainant?
Right.
But in
their relationship.
Well, I try and ask for outside of it,
of course.
too. But they will not disclose to you if the complainant has been involved in other complaints.
No.
And there's case law that says we are not allowed to cross-examine on other sexual assault allegations.
Right. Pending or otherwise.
Unless it was demonstrably
Right.
false. And what is that definition, essentially? A recantation.
Right.
Meaning if somebody's found not guilty at the end of a trial, as a judge finds in a written decision that the complainant is not credible, that's still not enough.
No. You have to
Demonstrably false really means
she said it didn't happen.
It didn't happen.
I lied.
Otherwise, we can't get it. And there is logic to say that when, it's kind of like, similar act evidence, you have to be careful, but there is some logic to say that if somebody has engaged in 2 or 3 other allegations, which have resulted in acquittals or withdrawals, something smells.
Yeah. Where there's smoke.
There's obviously some fire.
Oh, there was a lot of fire on this video.
But we can't get that evidence. We are just absolutely not allowed. It's barred. We're not going to get it. It's just not going to happen. We can bring a motion. We're not going to get it. And then we're not going to be able to use it.
And the poor clients, because I'm asked this question, well, why can't we check? Why can't we check other jurisdictions? We can't.
Yeah.
And that is just so tragic. Because I am convinced, now having dealt with her,
That there's at least 1 or 2 more occurrences.
I'm sure there's 1 or 2 more. This is someone who's...
You have to appreciate also how unusual it is in a practice where we've got, a fair amount of clients over 31 years, where, you actually get a complainant, the same complainant
on another case
within a 15-month period of time.
Right.
It's highly unusual.
Yeah.
And we can say this, because we know of it in the discussions with the Crown Attorney, that can be raised,
right.
But it doesn't result in anything at trial.
No. Nope.
So I guess the takeaway from this is a couple of things. One, we're building that anecdotal base of evidence to show that there are false allegations and it's real. 2, this type of evidence is extremely important. You don't often get it. And it just underscores why it's so important to be careful about these types of allegations. And 3, it's something that if you want it to go to trial, we should not have to disclose. If you really want it to go by the old strategy where you really want to surprise a complainant and there should be no reason against it because it is the subject matter of the charge, they know very well what the they've done. Yeah. They know very well that they partook in this. They know that all, and yet they're willing to get up in the stand and lie about it. Right. They should face this without any prior notice. And without having a lawyer talk about why it's maybe admissible or not, like a complaints counsel. And it's not a surprise
to them if they know what they did. It's not a surprise.
I've never liked the idea of trying to frame this legislation in a way to say it's sort of ambushing or surprising a complainant when they're clearly messaging each other.
Well, yeah.
They know what they're talking about, or where there's a recording where they clearly know what's going on in the recording. If it's something surreptitious, it's different. But
it's different.
I've never liked that angle.
No, I know.
All right. On to the next case. So if you enjoyed this, Pillow Talk. Can you do Pillow Talk?
Yeah, I can do Pillow Talk. We're going to get sweatshirts. Would that be good?
I would love that. Can they be hoodies so in the winter I can
the hoodie?
You
want that M&M look?
Yeah.
Marcy, did you hear that? So, folks, don't forget to like, comment, subscribe, and share. Please, we're getting high up in the numbers. I had someone in the courthouse come up to me the other day. It was like a fanboy. Almost wanted my autograph. I said, no, it's okay. Get Joe's. It'll be worth more on eBay.
I don't want to do that either. But, thank you for the support. And, again, we keep getting good questions, and we've promised to hit 2 areas. We still haven't gotten to it. One of them is that new online harms bill where we need to set aside some time because I've read it, I've reviewed it, I've commented on it. but it needs a deeper dive. So we're going to get to that.
We're going to get to that. We're going to get to Chat GPT.
Yeah, that's a good one that's going to come up.
It's a good one. No, it's really...
Because it's just rearing its head even more now.
It is.
Yeah.
Like in one of the cases I just had, a client ran his fact scenario through Chat GPT, asking Chat GPT to render a decision. It was interesting.
We got to talk about
another episode.
We got to talk about that on the next one.
Yeah,
So
yeah.
take care, have a good night, and thank you for
Thank
viewing.
you.